I was saying, um, we left off, we only have two standards left, and they are, which one is it? Hopefully we can get through them relatively quickly. We'll see. Let me know. We, oops. How is that for size?
We're looking at the 2-pager that you sent. Well, I know you did it in 2 chunks. So like,
Yeah,
um,
that I should have sent standard 8 and 9 to you.
yeah, it's a little small for me to look at on the laptop screen. And I printed out 8 and 9
Perfect.
for me, but I just want to make sure the separate 2-pager that was 8 and 9 is exactly what's on the screen.
It is, yeah.
Okay, good.
I just didn't want to reset. I think I resent a link to everything, but for ease, I just pulled out the two.
Okay.
And then you all always have the option of popping out this screen in Teams at the top, and you can put it on a bigger screen, which can be nice.
Oh, that's a good idea. Like where it says pop out. Done and
Yeah.
done.
And then you can put it on a screen and make it full screen. And then if you look at the lower left corner next to the names, um, in that screen, there's a zoom in button, like where it shows I think it's my name, probably sharing it. There's a zoom, so you can do your own zoom. But if you're in a lot of Teams meetings like I am, it's a pretty handy little thing.
Yeah, that was awesome.
Yeah.
I did not know either of those things.
Well, you're welcome. Yeah, they're much easier to see. So shall we start with standard 8, which is hearings? And I think the main, I don't know what just happened. There we are. One of the things I noticed right off before we kind of dive in is that the first two are, minus the offering exhibits, were things that were discussed in the previous standard and the prep for the hearings. And so I think we should talk about if we leave those in or modify them since they're sort of discussed above. But if you've reviewed these, I don't know if anyone has any general comments or if we want to just go and start with the language.
Well, my general comment would be I went back through sessions where we considered should or must.
Mm-hmm.
And our understanding when we chose to use must was that these were going to be the standards that we would train to and the expectations. And so I think that serves value, having a standard for a lawyer that has a contract that we can turn to and know that that's what's expected of us, and think that it should say must if we leave it in. And that includes must be where it says should be strategic. My note was, why not must on D.
Okay.
Well, and I see what you mean about it being there in the previous standard. I mean,
these top two.
Oh, but I can't move it up and down. So I'm trying to move it up to 7, but I can't do that. So only you can, Annie.
Yeah,
You're in control of my screen. Okay.
I am. Here's 7.
Yeah, I see what you're talking about where it's repeated.
Yeah, because I think it makes it clearer if we're talking about the participation at the hearings versus the preparation for the hearings, and keeping those two distinct and separate things makes a lot of sense. That, and then when you get to the making motions and evidentiary objections, in Dependency, the rules of evidence are kind of thrown out the window for a good chunk of our hearings. So I don't requiring us to make those evidentiary objections, even though they don't necessarily apply to those specific hearings, because this doesn't differentiate a contested jurisdiction from a permanency hearing or a shelter. So
well, go ahead.
Oh, it was just that, noting that, because I don't know about you guys, but our judges are like, Miss Kinsey, the rules of evidence are different for this hearing. And they kind of get pissed at you.
Well, I see an evidentiary objection as different from an objection based on the rules of evidence. So, I can imagine people offering information in that would, and you would want to object to it, and I would consider that an evidentiary objection, even though it, like relevancy always matters, like, right? Otherwise, we have a hearing that's for one thing, and you get to talk about anything. So maybe we would remove or do something to clarify that it's not necessarily objections based on the rules of evidence, but that they are objections.
So then why not say make motions and objections consistent with the, and
I
just
think
remove
that
the
works.
evidentiary part of
Perfect.
it. Yeah.
Okay. Yeah, I think that makes sense. And then it sounds like the prepping the parent client to testify, we're okay with removing since that was in the previous one.
Yeah, let's not have that discussion again.
Yes. And then the only one on this one is the semantics of it, preparing to call witnesses, I think is, you do, in your hearing, right, we are all considering if you're actually going to call your witness. Usually you have a plan, but sometimes that changes. And so, but the offering exhibits is relevant. And I don't know if we want to change this language or if that's kind of how
You
we
could
want
say
to
presenting, you can say presenting evidence and it covers it all. That's one option. Or you're not preparing to call the, you're evaluating needed witness. We're constantly evaluating witnesses like during the trial or hearing. So
maybe
The
it's
preparing witnesses is also in the previous one. So it would realistically just be offering exhibits and testimony to advance the parent client's position.
love it.
I like that.
so I will say up here, this does say that participation must include offering exhibits and testimony. So there are times where you choose not to, but I don't, is that,
times where you don't have any? Yes.
I think it's to advance the parent client's position. It makes it clear that
Okay.
you're only doing it to, you're only doing everything you do is to, if
Okay.
it advances. You could say if and when it advances the
Or just
client's
say
objection.
if applicable. Like if your client doesn't get you any exhibits, you don't have exhibits to give out, but that's a if it applies, if applicable.
Any preference on if applicable or if, I don't remember what Don said already.
Yeah, I don't like, something about I could be overthinking, but if applicable is just not, there's something about it that doesn't make it clear. Like we want to send the message that you could say if it advances the parent client's position or
Because there's lots of times where
to
there are some
advance.
exhibits that would
Yeah.
advance my client's position, but they don't get them to me, so I'm stuck there making the argument without the exhibit. So
Well, if you have them, and I can envision situations where my client doesn't actually hand me the exhibit, but they're an assessment of my work that I could have done as a lawyer would be to create the exhibit. Like, for example, I might get stuff in discovery that I want to use as an exhibit, that it is an exhibit that would advance my case, and the state is choosing not to offer it.
What about offering available exhibits and testimony? Because I think in the above, we did talk about, did we talk actually about evidence up here?
We did have a lengthy discussion about client's obligation to, we
Well,
can only do what we can do.
Well, we talked about it in relation to witnesses, but I don't know that we talked about anything about like evidentiary, like exhibits or.
I mean, we have a section up above about investigation,
Okay.
and not that that's exactly the same, because you can do investigation that you don't then utilize because it's not helpful.
Yeah, I guess I'm just wondering if we should have added a preparing available evidence for like for preparing available documents or evidence for presentation and trial, for potential presentation or in hearings or something.
You could just say in G, must take reasonable steps to prepare witnesses and evidence, including expert witnesses. Just throw the evidence piece in there with it. Otherwise, if we separate it out, it's going to say essentially the same thing, but for evidence and exhibits.
Put it in the front so we keep the witness part together.
Yeah.
Okay.
Does that seem to make sense? Okay. Because then it's available. Yeah, I think that works. Okay, so we're good with so then making motions and objections consistent with the parent-client's objectives and trial strategy, and making closing arguments that advocate for findings of fact, conclusions of law, and orders that are consistent with the parent-client's objective.
When we have trial strategy, is it, because this applies to more than just what I think of as trial? I mean, it's parent-client's objectives and case strategy.
Yeah, I agree. Because these cover more than just a trial to.
Oh, yeah, I hear what you're saying.
Right. Yeah.
Yeah. Because it's. Okay. And then making closing arguments. Okay. Are these looking good here? For A?
Yeah.
I think so.
Okay.
Viewing them as standards.
Yes.
Everything I say is acting under the assumption that I am preparing standards that would be incorporated into a contract, because that was the mission when the directive when we began.
And I for reference, I think in our other standards, the black letter law, which is in blue here, is considered kind of the standard, but the other pieces are made more of the commentary that were best practices. Mm-hmm. But ultimately the commission is reviewing this for all language, and so while we make these recommendations, there may be suggestions back that you would have a chance to discuss with the commission or make your comments known to.
Yeah, and not to get bogged down in this, in Annie, it's not directed at you in any way, shape, or form. Leadership has changed there. What was the directive to the work group? Who made the directive and what was it? Did the commission make the directive initially when they said set up a work group to establish blank?
I would have to look way back because it has been significant leadership changes since this started, and I don't recall if it was the agency-led initiative with support from the commission or if it was a directive from the commission. That the conversation around creating our own standards has been kind of a common theme, but I think since we started this idea, we are on our third or fourth director, and our third commission at this point, even, are a pretty different group of commissioners. And so I think that the initial goals and where we are today, there may be some difference.
That makes sense. Thank you.
Yeah. All right. Any issue with B here? Parent client's lawyer must be prepared to state and explain the parent client's position at each hearing.
I
That's
mean, I
usually-
wish they knew. I wish I knew my client's position at every hearing.
I was gonna say, as long as it includes the option where your client just doesn't talk to you and doesn't want to talk to you, then yeah, that's fine.
that I think that is a position. Is there? I have no information for the court. Is a position. C, the parent client's lawyer must be able to effectively present witnesses to advance the parent client's position. The lawyer must also be skilled at cross-examining opposing parties' witnesses. The lawyer must know how to offer documents, photos, physical objects, electronic records, etc. into evidence.
Well, when you say effectively, I mean like ask questions that, right? Like sometimes it might not be an effective witness through no fault of my own. And sometimes my questions could have been better. So by effectively, I meant like confidently, I'm confident, not the words out of the witness's mouth are
Right.
what I anticipated.
I mean,
We've
do you
all
need to
been
get
there.
qualified if you're not able to do this?
Right. Yeah. I
The
mean,
dependency standards right now are you observe 5 trials. So do you think that somebody observing, I mean, I think that the way I think about this is some of these are pretty straightforward and kind of like yeah, of course you should be able to do that. But if somebody is not doing that, it is helpful to have a standard that we can point to and say, hey, this is part of your job. You need to be able to do this. Because the standards are more about the qualifications are, being familiar with the rules of evidence. There is a preamble to it, but a lot of it is more specific to knowing the area of law, not always being competent in all of the trial skills. I can pull those up too.
I was gonna say, I think we redid those and we were talking about having like a trial practicum option in there so that you do have those kinds of skills and stuff.
There is a lot more in there, that's true, that has
Yeah.
changed significantly. So
The other last thing was just the lawyer must know how to offer documents, photos, physical objects, electronic records, etc. into evidence. Does that include knowing how to plug it into the screen to get it to cast right? Because that I don't think anyone remembers how to do every single time you go in to do it.
I can't
Must be
see you
willing
because
to
so I don't
learn.
know if you're a boomer or not.
No, I'm a millennial, and it's hard for everybody, all right?
Because I just fall into the boomer category, and that's the joke I get to make of myself.
Yeah, I mean, it is, I don't really have a good answer. I mean, we could specify offer into evidence or offer for the record or something.
Must be able to. Not necessarily that they absolutely know how to, but must be able to.
Must
child
know how
must
to ask
provide
the
the
clerk
parent.
for help.
Right?
Yeah. I mean, the thing is that typically y'all figure everybody is kind of on board on that point and trying to figure it out. Usually, in my experience, it gets done, but
Well, think about this. Like now that we have OECI and rules on how to introduce evidence and how you file it, I think the standard has to address that. You either have to know how to do it if you're a solo practitioner, or have someone in your employ someone that knows how to get it in the system for you. And am I right, Jennifer, that there are supplemental local rules on what they expect? So I think the standard should indicate that you know how to get the evidence into the system for yourself, for your case. Somehow say it. I mean, I understand you go in and your adapter doesn't work and the court doesn't have the right one either, and that you're just finessing it, right?
The
I mean,
lawyer must.
you're being as graceful as you can to get it figured out, but
the lawyer must prepare to offer. So that indicates like if you don't know how to offer this weird TikTok clip that somebody sent you, that somebody else posted, that you learn how to do that before the hearing so that you're prepared to put that in for the hearing. Because there's a lot of different formats for things that we just don't come across very often. So the idea that I would know how to do all of those at any given point in time is kind of not feasible.
Well, but this is for the hearing specifically. So when you're in the hearing, you know how to do those things. And so I think if you had something like that before, that's part of your prep, is figuring out how to get it in a format to present to the court.
So maybe we do need a separate thing in the preparation part that states that you're prepared to do this section. So, because we talked about offering exhibits, right? And we needed to add in the prepare evidence and witnesses. But then maybe we should also include and have a separate one for evidence then that includes preparing to offer all of these different types of exhibits into the record per your local rules or something like that.
Well, preparing evidence, I think, encompasses preparing it to be offered regarding your county's rules.
How dumb do we want to make these? Like,
I know that's exactly my question was exactly that, because you said it better than me. It's like, what is the purpose of this is to say that if OPDS is hiring you, our standard is that you're at least as a lawyer gonna figure out and do something to get the evidence in. You're not gonna, doesn't come in because I didn't know how to do it, right? That's what the message you want to send. Am I right, Annie? You want to say,
yeah,
we've got a bottom line here.
Right. I'm thinking,
And
knowing how to lay foundations, knowing how to, it's not just like some of the tech stuff, but it's more about you understand what evidence is, and you understand that the court you have to follow some certain steps to be able to enter evidence into the record. Both to be prepared, share it as needed, and then lay over all the necessary grounds for entering it. I mean, I think so. I don't know. I would be inclined to not get as deep down into it, but I would also, I hear what you're saying.
I mean, some of it is that it's going to keep changing, like what we have, and if we have an exhaustive list or kind of exhaustive, I remember trying to figure out how to lay a foundation to get text messages in when text messages were new. And now the TikTok
yeah,
which sort of terrifies me to think about somebody offering one of my clients TikToks, but not that I've actually seen any of my clients TikToks, but I can only imagine. Yeah.
So I sent something about the preparing thing in the chat, because I think if we do something that just mentions evidence and exhibits in formats consistent with local court rules, that then tells you where to look for that stuff as a new practice. Because I started this almost 4 years ago, so I still feel very new. So as a new person, being able to pick that up and go, okay, I need to learn, where do I go and learn that from? That at least gives you a hint in the right direction of where you should go.
So you're thinking of putting this in place of moving back up here?
The G, yeah, because it's definitely more of a preparation thing.
To prepare witnesses who have been identified in addition to evidence and exhibits in formats consistent with local court rules. What do you guys think? Yeah.
Yeah. Okay. I think that's good.
So did you just, now I'm trying to figure out the best way to make it.
Sorry.
I'll just copy and paste it for now.
Jen is our real wordsmith.
Yeah.
I like words and I like writing them down, and writing them down helps me understand it better. So it's much nicer. I'm one of those weird people who's like, if it's something tough in a hearing or a trial, I would prefer a written closing than a verbal closing. So it gives me time to organize it and make it pretty.
I like that in theory.
Time wise, it's a suck.
Yeah. Yeah. Jen, I was at the safety framework training last week. Dawn was too. And I came in a few minutes late because I had a permanency hearing. And the seats left were the Washington County table. So I sat next to Hannah. And then I look over and I was like, oh, Judge Reenie's here. Okay. Like, she's terrifying even when she's being nice.
Yep. And it's weird to be in model court as well, because then you've got that, like, there's a level of banter and like commiserating about just the realities of the job. And then she gets back on the bench and you're like, I don't know where that line is now.
Yeah.
Some things will never change. Yeah. Although she was just a referee when I was out in Washington County. Not that that has changed her much, I don't think, but
We were laughing that Hannah and I, all standing next to each other, like we're basically like the same person, height wise, size wise.
Mhm.
it's funny. Okay.
I
So
told her
does
she looked shorter than she did on the bench.
Bring her down to the peg or two.
All right, so we're good with this, and then we can move down here to so now it's knowing how to offer these documents.
Yeah, that makes sense.
Um,
It feels less like it's coming out of nowhere then.
okay, and then did you Don or Don, yeah, Don, you had mentioned maybe changing this to competently present witnesses to advance the parent client's position as opposed to effectively, since there's only so much you can control on a witness.
Yes.
Okay, does that seem reasonable to y'all? Okay.
Yeah, no, I like that. I mean, when our clients get on the witness stand.
But yeah.
And you object and object and object because they keep running their dang mouth and you're trying to help them out, but they look at you like you're crazy. Yes.
Yeah.
Yes. Where
No
you
one
ask
But
lets
just
me
remember,
talk.
you didn't present that witness
That's true.
in most cases.
Yeah, but we've all also had those witnesses that you've talked to endlessly, and then you put them on the stand and you ask them a question, and you're like, oh, that's where we're going. Okay, great. It's not how we discussed this going, but here we are. Okay, and then the lawyer must also be skilled. Should we say skilled, or should we also say the lawyer must be competent at?
I think it's good to make it consistent because then people will read too much into the different words. Or
You mean all the
be.
other lawyers out there that this is for are going to sit and pick apart each specific word and figure out, oh, well, this is different than this, and this is different. And it carries a different meaning now.
I love that that implies that everyone is reading these and trying to think on how to use them. So I will take
They were
that.
part of our contract. They would.
Not only are they going to read them, they're going to scroll back through these videos and recordings and go, what did they mean by that? What is the legislative history on that?
I know, right? Isn't that nice? I will say we have this, but we also, I believe, reference the Oregon State Bar standard. So anyway.
Cool.
Yeah, lots of places to look at for things. Okay, so I think we're good on C. And then D, the parent client lawyers must be strategic in determining when to request and when to make an opening statement. We don't have anything. Oh, we had something about closing above. Yeah, make closing. Okay. in the standards, some of the other standards, those were combined, the opening and closing, but this makes sense to me. And then E, is there any other issue with D, or are we good to move on here?
I'm good.
Okay. And then E, if the court proceeds in the absence of the parent-client's lawyer, the lawyer should consider filing a motion to set aside.
Yeah.
I mean, yes, but do they really do that?
Yeah, I've done it.
Yeah. And then the best practice here, the why I'm struggling saying that. Parent-client's lawyer should seek out training and trial skills and watch other lawyers to learn from them. Presenting and cross-examining witnesses are skills with which lawyer must be comfortable. In particular, examining or cross-examining a child requires unique skills.
If there were a class out there where they would sit you down and talk about how to cross-examine a child of varying ages in a trauma-informed manner with your client as the parent saying, oh, no, don't do that, or oh, yes, do this, ask them this. Like, I don't know that that class exists.
No, yeah. I think honestly, the most I see about client witnesses is in child sex cases, and cross-examining them in those settings. But I did see, I don't know if ever you got the training that's happening in Seattle with NAPD and Seattle Defenders. That seemed like a very interesting training that they're trying to do every year, I think. And I would bet that they'd be open to hearing about getting something like that on one of their lists. It looked, at least I'm not going to that training. I don't know if any of you are, but it looks very cool.
It already happened.
Oh, it happened. Was it cool?
I deferred so other people could go, but I'm getting good feedback. I'm
Okay.
getting really good feedback. Ryan Newby went, Kelly Nealand, and Liz Wakefield.
Yeah, because I think we all know that how limited the trainings are in dependency, especially when it comes to parent representation or kind of that role. People love focusing on the kids a lot, and this seemed like a very good beginning or training that was going to focus more on kind of some of those aspects. So
I mean,
fingers crossed they continue.
Severely lacking. I created a CLE on the criminal and dependency for parents interaction and how you deal with no contact orders and things like that and what your practice should be, because it's zilch, nothing out there.
Yeah. Well,
maybe we should
we'll
create it. Maybe that's what comes out of this group, is creating a how to question children.
Liz Wakefield is on the education committee. You should email that idea to her and the juvenile law committee.
Okay.
Yeah. Okay, standard 9, last standard here. Post hearings. The parent client's trial lawyer should take reasonable steps to ensure the parent client and all other parties comply with court orders and should continuously assess whether the case needs to be brought back to court.
I would recommend that you scratch trial lawyer and just say lawyer. You use lawyer throughout everything else.
And all other parties. Okay, any other comment on A?
I do. I need to decipher my own handwriting.
All right.
Oh, I think we wanted to take reasonable steps to advise. I think I suggested that maybe we add the language advise the parent client regarding
regarding court orders.
Regarding court orders. I think we want to advise our clients, but it's not beyond that. That's not our job, right?
You mean ensuring? So instead of ensure, say, change this to say the parent client's lawyer should take reasonable steps to advise the parent client. Well, I don't know. What about all other parties?
I wouldn't say anything. I wouldn't say reasonable steps. The lawyer must advise the parent client regarding complying with court orders. That's part of our job, like the pros and cons of complying with court orders. And then something separate about take reasonable steps to ensure that all other parties comply with court orders.
Oh, I see. Okay, so let me
Because
get
we might not want to say anything strategically, right? Or we might. So
I think what
to
we're
the other
doing
about the other parties.
here is what I'm gonna try and do, see if this works. So change these into two set. I mean, I'll mess with the formatting here shortly. So the parent client lawyer must advise client
I would say regarding issues relating to compliance with court orders. And when I think of, I say it that way because you might get a court order to do you might lose a dependency trial regarding whether or not you were the perpetrator of sexual abuse against your child, right? And then you're going to get a court order, you lose, the court order is going to say engage in a psychosexual evaluation and treatment. You're going to advise your client about the pros and cons of that.
Yeah.
And then
so Jen put some language in the chat that is just the parent client's lawyer should advise the parent client about complying with court orders.
yeah.
And so just yeah.
And I like the second line too.
Because, like, if somebody is not following a court order, like DHS is not following a court order regarding visitation and your client's getting more visitation, I'm sure not bringing that back to the court. But if they're not providing the visitation they need to, I'm definitely going to bring that back to the court. So it's not just as simple as are they complying, not complying? If they're not complying, let's bring it back. And if my client is not complying, I'm not going to flag that for the court and tell them to hold a hearing on it. And I don't know that continuously assess is good language either, because then you're sitting there going, okay, do I need to schedule time every week to go through all of my cases and figure out which ones are complying and which ones aren't? Because that sounds like a caseworker job.
No, but I do kind of but the idea of having a responsibility to assess when a case should go back to court, I think, is important.
And I think that's consistent with the evidentiary codes too. You're remaining the lawyer. And it's like, for example, as discovery, we get rolling discovery in Multnomah County. Like discovery comes in, you should read through the discovery. Once every, the bar would say once every 30 days, you should assess where your case is, a case is, if it's still open, regardless. So like, you should be assessing where things are. In some counties, they set the case, they go from jurisdiction to permanency hearing. And yeah,
well,
those are the hearings, right?
Or it'll be, you don't come to court. Like in in many counties, you have a hearing, you have the shelter, and then the trial. Well, if there's a trial or hearing, or admissions, and then it's 6 months, and then it's the perm hearing. So I usually see a review, but it's like 6 months before. And so there are cases that you only have 2 hearings before the plan is proposed. Like there's a plan to proposed change or something. So that is a county thing we've heard of in other counties. Like Multnomah County has the most hearings, I think, of counties since CRBs are canceled. But many other counties will have CRBs and then you come to court once a year, twice a year, which is different. So yeah. So let's see.
I don't, hear me out. I don't think that we should say take reasonable steps to ensure the parent, client, and all other parties comply with court orders. Because again, that feels like the caseworker's job. Like I'm not here babysitting cases. I
was removing that.
Yeah.
Because we sort of have that up here.
So then the question becomes what word to use about the frequency of assessing.
How about regularly or I see the problem with continuously. That means like you're constantly rethinking. You can't be thinking about it continuously. Like I think of directions that say continuously stir,
Mm-hmm.
you know, so like routinely or regularly assess, or just some systematically assess maybe is a way to think about it. And if you're using a system, you're going to base it on the need of that client. So you have
So
a lower.
sorry, what was it you're saying about the bar having like a 30-day rule?
Well, I think it might not, it's not a rule. The bar doesn't set those kind of rules. But
Mm-hmm.
my recollection is in training materials, I've seen that there is some kind of expectation or recommendation for training and how to be on top of your cases, that you touch a case every 30 days. Like if it's open every 30 days, you should be thinking about why that case is still open. Like, was there something I needed to do? Is there a letter? Did someone not follow up with me about returning the contract? Or has the check not come from the other party's insurance agent yet, or whatever?
Right.
So would it
And
make sense? Sorry, go
go ahead.
ahead. I will
No,
type.
no, no. You're good. Go ahead.
So would it make sense to say the parent client's lawyer should assess cases on a monthly basis to determine any needed action?
I'm reluctant to put in a month, because what if you have a cognitively low client? I mean, it should be determined based on the needs of that client. Like some clients I know my phone number and they call me when they need me, and I'm not regularly assessing and following up. And then I've got like a mom with a lower IQ or who's afraid of and easily pushed around, and she's never going to call me, but they're canceling her visits every week. And so I'm checking that person more than I'm checking the one that I know is on top of it.
Okay, let me think and type for a second.
This is also, I will point out, a should here, and as is this, and this should probably be a must.
Yeah, I would agree on the must.
And then what about here? And the second one, parent. I know Jen's working on some language that she's going to put in here shortly, but
I think it should be a must.
I agree.
And we've got 3 minutes left. I'll just tell you, it's a family member's birthday tonight. And so I do need to leave at 6
okay.
to be in an event. So if you guys can continue without me.
Maybe what we do, Don, is I'll take the temperature, but since you might be on the tightest timeline, we might come up with some proposed language and just, since it's 3 left, and send those out and say, here's some proposed language. Please provide feedback. If people want to set like a short meeting to discuss this, we can, or if people are comfortable with this language, we can just proceed with as is.
I defer to others.
Okay.
I can stay on for a little while. I'm sort of waiting for a text from a kid about when she needs to get picked up.
My partner is currently watching my kids and they're in the other room, so I am fine. The longer that happens, the better for me, right?
All right. So your proposed language here is we'll try and get through this one with you, Don, though. The parent client's lawyer must determine a reasonable frequency at which to assess the progress of a case and take any necessary action for each case.
That's good.
Any preference? Okay. And I'm going to clean this up here. So it's going to be repetitive, but I want to make it as more, cleaned up there. All right. And then the last, once an order or judgment is final, the parent client's trial lawyer must provide the parent client with a copy of the order or judgment and should review the order or judgment with the parent client to ensure that parent client understands it and the client's obligations under the order.
My feedback on that was, it is odd that the first one is a must and the second one is a should.
Yeah.
And your client, sometimes my clients don't want a copy of the order, you know. But I think at a minimum, you must review the order unless your client's like, F you guys, I'm out of here.
Well,
That
I
happens.
yeah. I mean, I think there's also I'm providing this to you. You're choosing not to take it.
But if you're,
Is but yeah, that's maybe
right.
semantics. So, um, but it is 6, Dawn, if you wanted to
Yeah,
pop out here. But thank you. If you have any other things you want to pop in there, let us know. But otherwise, we'll be in touch
yeah,
regarding these final 3.
And I'll clean up on whatever my I have some notes. I'll see if you guys incorporated that and just give me a reasonable time to provide feedback. Take care, everybody. Thanks. This is hard work and I appreciate working
Thank
with
you,
you
Dawn.
guys. Bye.
All right.
Yeah, I keep thinking about all the clients I have that I can't find that which is not very many, but I feel like I always have about one at a time where I don't know where they live.
I mean, we could even just do must provide or attempt to provide
Sure.
the
Once
parent
an
client.
once an
Oh.
order or judgment is final, you must offer the client the opportunity to review the judgment, which may include a copy of the judgment if requested. Because I think ensuring that the parent client understands, I don't know what my clients understand or don't understand. Don't make me responsible for what they take from me. I'll sit there and talk to them about it. I'll explain it in 3 or 4 different ways, but once they leave that room, I don't know that they're going to take it all in and implement it the way that they should be.
Okay. Thoughts on that language, Jennifer? Ah. Is there a dog barking or something? But okay. Let's see. Once an order or judgment is final, you must offer the client the opportunity to review the judgment, which may include the copy of the judgment if requested. Judgment or order. Jennifer, are you still getting? Okay, there we go. Which should include a copy of the judgment.
So my problem is that I normally meet with my clients right after court or right before court, somewhere in that that time frame, or we're talking on the phone or something like that. So if I have to send them a copy of this, am I printing it out and making sure that they are given a copy? Am I emailing them a copy of this? Am I texting them a copy of this? Are they going to then sit through and go, oh, well, this box says this thing, or why didn't they check this box? And frequently the way, I guess, particularly in Washington County, the way in which our forms are for the judgments can lead people to having a lot of questions about things that weren't ruled on, that aren't actually contained in that order or aren't relevant to them, that then can sidetrack them from what they need to be doing. So there are times where, depending on the client, I will go over it with them. The judge ordered this. I will send you a text of what you have to do in order to meet what the judge is asking for. But if I were to give them a copy of it, they're going to get lost in the bureaucracy of it.
I mean, our office's practice is if the judge doesn't give a copy at the hearing, is to provide our clients with a copy in some way, email, mail, text. I mean, I guess I do feel like they should have a copy of the order in their case if we can get them the order.
Well, because then you've got our county does the included by reference. So in orders, the service checklist and exhibit XYZ. So then you're going to have to print out the judgment and the exhibit checklist and find a time to meet with them to give it to them or put it in the mail. And I don't know that they've got a mailbox that they check regularly or any of that nonsense. I think may gives that the option, but I think should, then you're going to have a bunch of people trying to do this. And let's face it, our clients don't have all of the executive functioning in the world. If they were able to review judgments like this or have copies of them that don't send them in a tailspin, they wouldn't be our clients.
I,
Go ahead,
yeah.
Amy.
Well, I hear what you're saying, but I also feel like that's part of the, like in my practice, that was part of the learning how to deal with the agency and having instructions part, that I would try and work with them and say, this is what it looks like and here's how we understand it. But I would also default, if able, to providing a copy to my client, because I've also had the circumstance where I've gone over things and they say, we never talked about that. I've never seen that before. And having the ability to fall back and say, you had a copy of that order, we talked about it and went over it, has been helpful reminder at times too.
And I think about, often psychologists will say in the psych evals we see, like, person needs to see this in multiple formats. And Jen, it sounds like you text your clients too.
Oh yeah, I'll put things in, right. I will give them here's step 1, I want you to do this. Here's step 2, I want you to do this. Here's step 3, I want you to do this. But the way in which our orders are written is essentially a giant form, and then the judge checks a box on this and not on this. And just looking through it sometimes gives me eye strain, trying to figure out which box was checked, which one wasn't. And it includes every possibility on there. And so the same thing when you get all of that, like PCR, protective custody report from DHS in the beginning. You're going into the shelter hearing, and I'll read parts of it to my client. I'll ask them questions based on it. Unless my client point blank asks me for a copy of that, which then needs to be redacted for anything they shouldn't have. Too often clients get caught into all the hearsay of it and needing to make sure, oh, well, we need to refute this thing. And I'm like, no, I need you to focus in this direction. And so it's about that strategy piece to it. And how do I get the client to understand that all of this is confusing misdirection? And this is where we need to go with it. And I review it with them. Of course I do. But the idea that I then give them a copy to sit there and let them go over and over and over and over again in their own head with their own voice telling them what to think and feel about that, I don't know. Sometimes it's just counterproductive, especially for a few of my clients who just perseverate like nobody's business.
I mean, I think that's where it's still the provider attempt to provide, because I would feel more comfortable in having that part of the conversation with the client and saying, I can give you a copy of this and here's what it is, or I can write down the things that you need that are that the steps to follow through and the main things. But I think that's, I still think there should be it should be an affirmative. You should have a copy, or we're going to talk about a copy, why you should have a copy, or what that looks like for you and the best way for you to be able to take in this information.
I definitely think taking out "if requested" feels important to me. I don't want to put the burden on my client of saying, oh, hey, can I have a copy of that? And I guess I mean in particular court orders. I think court reports, I'm just going to be honest, I go over those with my clients, but I don't typically give them copies. Or, lots of other things, unless they ask me. Probably because I don't want to have to figure out if I have to redact.
Mm-hmm.
And I totally, like, yes, I have clients go on tangents all the freaking time. I'm like, and the orders are confusing. I mean, the whole parent admitted to, allegation 4A, 4B and C were dismissed. And the parent is like, what allegation was that?
That is not the four corners of the document that we were taught in law school, but yes, absolutely. Like, it gets confusing like that. And I guess part of mine is like, that's my job as the attorney, is to keep a copy of that case file for you. Should you ever decide that you need it? Should you ever want to delve into all these different orders? Should you ever want to delve into all these different court reports? But that my job is to worry about what this says and communicate it to you in a way that enables you to use that information. But I'm totally fine with leaving the if requested off. And I think which may include a copy of the judgment gives you that discretion to adjust on a case by case basis. And then maybe we put in a, not a best practices, whatever it is that we're going to call these things, and say, having a conversation with your client about the pros and cons of them having a physical copy of, or an electronic copy of, each judgment and each court report and each thing that's filed, so that attorneys sit down and have those conversations with their clients rather than just making assumptions.
Well, because the other thing that is not talked about here, oops, I scrolled too much, is, I guess it does say once the order or judgment is final, because there's a lot of times the court will not give you the order in court. And so there's like, you go over what the judge said in court, but then when they write down the final judgment and they actually put it in the file, or, disseminate it, there's that process of reviewing it and then making sure it comports with what happened in the trial or in the hearing, and that your client understands if there are anything that you missed in that explanation. So, but yeah, this one. So are we comfortable putting this language minus the if requested, that once an order or judgment is final, you must offer the client the opportunity to review the judgment or order, which may include a copy of the judgment or order? Okay.
Yeah, I think that works.
Must.
Oh, the only thing I wonder is how, because it's not just that we're giving the client an opportunity to review the judgment on their own. I think what we've been talking about is reviewing it with them. Is there some way to like make that a little more explicit?
I see what you're saying. So yeah, once in order, you must offer the opportunity to review the judgment together.
Sure.
Yeah, that's clean and simple. Yeah.
And then should we move this stuff to the down below, kind of when reviewing a copy of the judgment or a judgment or order with the client, you should be ensuring they understand their obligation under the order or judgment.
I mean, I think Jen had a good point that we can't ensure they understand. We can, it's like when I have DHS caseworkers say all the time, I was very clear with your client about what they needed to do. And I'm like, yeah, communication goes both ways. Like, just because it felt clear to you doesn't mean my client understood.
So then, are we just good with this? Once an order or judgment is final, the parent client's trial lawyer must offer the parent client the opportunity to review the judgment order together, which should include, does that read right? And maybe when reviewing any order or judgment with a client, the parent client's lawyer should endeavor to explain the material in multiple ways and discuss whether the client should receive a copy of the judgment, the order of judgment. Are you saying, Jen, for that part to be below or in the in this section itself?
I think below, because that's more of an instruction on like, here's how to accomplish this standard rather than a this is the standard. Does that make sense?
In the best practices part?
Yeah. The best
Okay.
practices or hot tips or whatever it is that we're going to call them.
Yeah.
Recommendations?
Yes.
I'll kind of wordsmith that a little bit, or maybe just switch. Since we always do it in that order above.
Oh, yeah, then the one above it should be changed too.
Where? Oh, yeah.
When you're reviewing any judgment or order.
All right. Let's see if we can get through B here. I mean, are we still good to go here? Are you guys needing to? Okay. If the parent client is unhappy with an order or judgment, the lawyer must counsel the parent client about any options to appeal, or if the order was entered by a referee, request a rehearing pursuant to ORS, but should explain that the order is in effect unless a stay or other relief is secured.
That seems fine.
Yeah.
Should this be a must for per Dawn?
Yes.
Yep. Excellent
Okay.
channeling, Dawn.
And then if an appeal is consistent with the parent client's objectives, the parent client's trial lawyer must timely facilitate the appointment of an appellate lawyer. I think this needs to be if an appeal is consistent with their objectives and the client or the client requests an appeal.
Yes.
Should it just say if the client requests to appeal? Because even if it's consistent with their objectives, you're not going to file it without talking to them.
But I think you should also be evaluating if you because they're not going to know. Like there are times, even if they're not necessarily unhappy or like we still should appeal this because of X, Y, and Z. You know, it's like, okay, this happened, but if there are good grounds to appeal or certain issues. So I don't know that it's always just when I kind of like the idea of it. Like it might be that if it's consistent with the parent client's objectives, discuss the merits of an appeal, and timely facilitate the appointment of a lawyer, and if the client requests to appeal, facilitate or something like that.
So what if instead of saying in C, if the parent client is unhappy with an order or judgment, what about saying if an order or judgment is inconsistent with the parent client's objectives, the lawyer must counsel the parent client about any options to appeal?
Or should we just say the lawyer, should you counsel? Yeah, I guess, do you counsel if you have a good outcome? Should you just in every setting, like, you always have a right, well, you don't always.
I mean,
When you have a right to appeal, you should talk to them about the right to appeal.
my client wins a contested jurisdiction. I'm not going to tell them they have the right to appeal that. They're done. DHS is gone. Like,
yeah, that's true.
Or a contested perm that you win.
Yeah. Okay, so put the language up here. If the parent
if I could spell, this would be faster. Objective.
It's still faster than me trying to remember and write it all out. So
if a judgment or order is inconsistent with the parent client's objectives, and then that comment is fine, and that the lawyer must counsel the parent, et cetera, et cetera. Because then for D, we can just leave it if the parent client requests to appeal.
Yes.
Do we do parent client? I'll go check. Yeah.
Yeah, it's been parent client, even though it's a little clunky.
It's all of it's very
Yeah.
clunky.
Parent client request to appeal the
Parent client's lawyer
must timely
must
facilitate.
because we can't. Is it
Must
facilitate the
submit,
appointment? Submit the form.
uh,
A referral?
An appeal. Yeah. An appellate referral.
Yeah, an appellate referral sounds correct.
All right. We did
Okay.
2 of them. I'm so impressed. I have to hop off.
Okay. What I'll do is send these out to everybody since there are so few of us, and then see if people want to provide feedback. And if it's enough that we need to have a meeting, I'll schedule one. Otherwise, we'll do it by writing and go from there.
Cool.
Thank you.
Sounds great.
Thank you all. I appreciate it.
Thanks. Bye.
Bye.